board member in my community, small community, 86 homes. And what immediately became evident to me is that the board was working on a good old boys club. So they had certain members of the board who, one was a realtor, who wanted to be able to sell every home in the community. There were a lot of things going on in secret. Individual board members would decide things for the whole board, and the board wasn't making any real decisions. So the president basically in bed with the community manager, landscaping contractors mysteriously did all the landscaping on the individual homes of the board members. And I was the treasurer, and I started looking into it. It became much more evident to me that the financials were being, again, managed by individuals and not so much what should people were being charged for assessments, and yet other people were being forgiven for assessments. There was times where the association was paying the late fees of individual homeowners, but then doing litigation against other homeowners that were widowed elderly people. So that's the mixture that I was exposed to. And ultimately, I quit the board and really started contesting open meeting violations. I took my board and my association to court through the administrative law judge process on 4 counts of open meeting laws, and won all 4 counts. They were blatantly violating the law, and it was so rampant that the judge actually fined the association the largest fine that they had ever given to any association. So a small community, 86 homes. But that particular case gave me some notoriety, and a lot of people have mimicked and used that example in similar suits in the court. So ultimately I got invited by a senator to work on a working committee, and that's where it all started. So that committee started, it became essentially a bitch session of what things their individual communities worked against. And I said, okay, we can sit here and talk all summer long about things that are bad. What are we going to do to fix it? So I started drafting proposed legislation for the group and that particular senator to address concerns. And from that small group, probably 15 people from across the state, different age groups, different experience level, I created the coalition, and we went on from there. So we started at about 15 people, and now we're close to 2,500. My degree is in chemical engineering. I've worked in nuclear power almost my entire career, 30 plus years, both in Navy nuclear propulsion on the East Coast and West Coast. And then I went to commercial nuclear and ultimately became a corporate director of a Fortune 500 company that ran, I think we had 12 nuclear power plants across the country. Contacted a lot of similar advocates across the country, from Canada, Washington State, Florida, Pennsylvania, and we collaborate on a lot of issues. Each state is very unique to themselves, so there's not something that we can do. And yet, while there are a lot of people who are trying to get an organized national effort for HOA reform, I find that it's so unique to individual political culture of the state that there's very little value. I do watch legislation from across the country, but I get most of my inspiration from communities here in Arizona.
Got it.
I'm a registered lobbyist. The only thing different from me from most lobbyists is I don't get paid, but I have all the lobbying requirements on me that any other paid professional lobbyist would have. How is your work going to affect me? Sometimes there are things that I'm doing that won't help them from their perspective of their issue. What I find and what is my biggest obstacle is when I first got started in this, it was very evident that the legislation heard only one perspective, the perspective of the industry. You had the builders, you had the lawyers, you had the community managers, you had the realtors. Those people are people that their incomes come from these communities. These communities are essentially entitled to unlimited taxation on the residents. So that's a an unlimited source of income, and all of these industries feed off that capability. And our legislation was driven by those lobbyists. As far as I know, I am the only lobbyist in the country representing homeowners to their legislature. What I've tried to do in every legislative session, sit down with legislators and explain what perspective we're trying to do. The homeowners are their constituents. The industry are not their constituents. They hear a lot from them. And they, in many cases, get a lot of political contributions from the industry trade groups. But the legislators work for the homeowners, for their constituents. And with the voice of the homeowners, the legislators listen. And we've been very well received. There's a lot of angst about too much government interference. And I really don't look for that. What I look to try to do is find legislation that establishes bounds on these communities and balance the power between the board and the homeowners, to have internal checks and balances, not external checks and balances. I don't want the government, I don't believe that the government's ever fixed anything and ever can. And if it gets involved, it usually breaks it more than it fixes it. So I want the people in the communities to be able to self-govern, self-regulate themselves, so that if the board gets out of hand, there's some ability of the homeowners to interject and to correct without litigation.
Right.
Litigation in these communities is a no-win for any resident. No matter where it is, it only feeds the pocketbook of the attorneys that are involved. Associations don't win, and homeowners win or lose in the case. They always lose because you're always going to pay some of the expenses. So if we can avoid litigation, we can let the money that's used in these associations to actually do what it's supposed to do, which is keep the community up to standards that we all want. But the boards are all volunteers from the community. They may or may not have a lot of experience. You know, if you have a smaller community, you know, George, Betty, and Joe can run it for their own interest. When you have a community like yours of 4,000 plus people, it's a lot of effort. I don't ever underestimate the effort and the commitment that's required of any board member. And we have to give them some kind of deference. But what I work to do is to balance so that the board cannot exclusively dictate to the homeowners. The homeowners have some say in the decision-making process. And that the board works transparently, because my fundamental belief is transparency builds trust. If there's trust between the board and the homeowners, then you start getting respect. And with respect, you build a community. So to focus on transparency builds the trust that can make this community a better place to live. And that's what I look to try to get to, is make sure that these actions are open, transparent, and for the benefit of all. There's an organization called CAI, Community Association Institute. It's a national organization, and it was the driving organizations for HOAs and condominiums across the country. So it exists as a national organization. There's one chapter in Arizona. There's a chapter in every state. They fundamentally represent attorneys. All the attorneys that work in these groups are supported by the CAI. They do have qualification trainings or training sessions for community managers. So there are some community managers that get their certifications from CAI. But fundamentally, lawyers and community managers under CAI. Each state has a separate organization for simply community managers. So the Arizona Association of Community Managers, AACM, represents their member organizations. They're essentially a political action committee looking for, and they do also provide training and certification for community managers. Both those certification programs are what I consider participation trophies. There's little testing, they're taught by attorneys, and you go and you get your certificate. You pay your money, you go and you get your certificate. what you know out or what you take from that, I see on the back end, and I basically don't see an awful lot of constructive knowledge. The Builders Association also are basically the fundamental builders of all of these communities. There are large builders that do a fairly good job. You know, they have a somewhat standard set of CC&Rs that they build, and they build their community. But they build their community, then they go off and they build another community. So their interests are to, they make a major investment into the land, into the building. They want a return on their investment, and they want to go on and build more. Their reputation is very important to them. But in the same light, there's also a lot of what I call fly-by-night builders who build communities, create outrageous CC&Rs that empower them, and they have no desire to build any more. Their entire base is founded in one community. The homeowners in those communities are at an extreme disadvantage. And then ultimately the realtors. The realtors, sell all of these homes. Their interest is in getting the home on the market, getting as much as they can from it, and getting it sold. Getting it sold is the ultimate goal, okay? There's a lot of, as an example, there's a lot of legislation. My first focus in legislation was on the resale disclosure requirement in these communities, so that home buyers were buying in these communities with knowledge of what they were in fact committing to. So many buyers buy into here and they assume, the CC&Rs they're all standard. Well, they're not. There's 10,000 different communities and 10,000 different sets of CC&Rs. The knowledge of what you have in those CC&Rs and what you're committing to, people are often surprised after the fact. And I wanted to be able to get some more detail into that disclosure. The realtors fought that. They fought it because too much exposure would risk their sale, And my perspective was find some difference where the real value of one community would compare against the less value or the more risk of another community, and the property values of the good community would go up. The property values of the bad community would go down. So the HOA, if exposed to the full, would essentially control the value of your property based on their performance, not necessarily on the physical real estate market. So, if you start seeing that your policies are causing friction or concerns within the community, then I think it's prudent to say, okay, are we the problem or are they? And a lot of what I see is the immediate assumption is people are refusing to comply, as opposed to, wait a minute, am I really doing what I should be doing? Is my policy wrong, or are other people simply resisting that? And I think a good, healthy self-examination of what you're trying to do for your community goes a long way. But I don't think there's any regular review. Do it based on what are your experiences. There are things that you are entitled to do within rules and policies, some of which are defined within your bylaws. But one of the big concerns that I have is your CC&Rs are essentially a contract. The board is equally responsible to living up to that contract as the homeowners are. They're to one thing. But rules and regulations outside of the CC&Rs, that's an area that's been abused substantially, okay? There are, in fact, under common law, very little that associations can do in the rural area. But there's a community like McDowell Mountain Ranch in Scottsdale. Their CC&Rs are 45 pages long and their rules are over 100. The minutiae that are in those rules. It's a beautiful community. I even looked to buy in that community, but when I saw their rules, they would measure how far your car is away from the curb in your driveway. They have a rule that says what direction you can park your car in your own driveway. Those are the kinds of things that are nuisance, that you actually, the association has no right to do that. That's where the boundaries are. But whether that association will ever review those policies, they won't unless I come up with some legislation that would mandate them to do that. And I have drafted legislation this year that would address that. There is common law principles and case law decisions and across the country on the enforceability of rules and regulations, what they can and cannot do. It's very general, but those kinds of detailed minutia things are really not something that's enforceable. But taking anything to court is an expensive proposition, okay? I have seen cases relative to HOAs with over $300,000 of legal fees, and that have been appealed all the way to the Supreme Court. But without the financial resources to do that, and the existing law has very little enforcement accountability. So to risk that kind of money over challenging a rule about parking is probably not in anybody's best interest. But what I want to try to do is to set up some general guidelines for these communities about this, the boundaries I talked about, of what their authority is, honor that authority, protect that authority, but make sure that they're not abusing that authority to beyond what they are committed to in the CC&Rs. The basic premise of that law, in 2014, the legislature passed a bill. Nancy Bartow was the sponsor. She worked for 3 years to try to get a bill that fundamentally establishes that if the association doesn't own the streets, they have no authority to regulate the streets. The streets have to be regulated by the owner, the person or the organization that's required to manipulate it. The cities have no authority to abdicate that responsibility back to the association. They are glad to accept that because they don't want to have to be bothered with it. But when the developer gave the property to the city, he had to build the streets based on the codes and standards of the city. It probably cost them 3 times as much to build those streets to meet code requirements than if he didn't give the streets. If he built them just for himself, made them private streets, there are no standards that would apply to the building of those streets. And most municipalities will not accept a street that was not built to their code. So after the fact, you can't go back and say, I'm not going to be responsible to maintain it. City, will you do it? They won't do it unless you tear it all out and rebuild it to their standard. Most communities can't do that. So the premise of the original 2014 law was, if you don't own the street, you can't regulate them. But it had a limitation to CC&Rs that were recorded after December 31st of 2014. What we did in 2023 was again try to get rid of that grandfather clause, essentially. But we weren't able to get that through the legislature. So what we did, and I was involved in that legislation from the beginning, is we just said, we're going to give it up to the community. This is not a change in your CC&Rs. Your CC&Rs say that you don't own the streets, but that you can regulate them. What this is saying is public policy is established that you are having a one-time vote to decide if you want to continue to use your streets to regulate your street, the association regulate your streets, or turn it over to the municipality. If the associations own the streets, they are able to regulate it in any way they want, whether it's parking, speed bumps, whatever they want to do. And the argument that's being presented by a lot of associations faced with this vote is they try to scare the homeowners into believing that if you don't approve this measure to allow us to regulate the streets and the parking requirements, that recreational vehicles, trucks, emergency vehicles will never be able to get through our streets. And that's absolutely false. You go to any municipal street of a residential community, you don't see our RVs on the street. You don't see commercial vehicles on the streets. You don't see a lot of parking restrictions. There may be some if the street is narrow and the city believes that it would be difficult to get fire trucks or emergency vehicles through those areas. They have the right, and they do regulate one-side parking, whatever, depending on the physical characteristics of your street. Their duty is to protect the homeowners on that street. They are liable if they don't put regulations on there that allow their emergency vehicles access to those roads. The city would be liable if they didn't do that. They're not going to risk. All cities are risk averse. And the reality is cities have been regulating streets long before HOAs ever existed to deal with the traffic associated with those residential communities. So the power of the city is actually greater than the power of an HOA. They can ticket a vehicle. The owner of that vehicle is the person liable for that ticket, not the owner of the home that the vehicle is parked next to. That vehicle may have nothing to do with the homeowner, but the association doesn't know who that owner is, and they can't ticket a vehicle without knowing that that person is subject to their governing documents. The city has the ability of the police being able to do that, and the ability to actually tow a vehicle in violation of their laws. The HOA has no authority to do that. They cannot tow a vehicle that's on property that they don't own. They could tow it if it was on their property. They can't tow it on municipal property. So the ability of the city to manage the streets is actually better than the ability of an HOA to manage the streets. And from my perspective, I don't feel that anybody should give the association power they are not entitled to have. Because maybe not now, but someday in the future, they will abuse that power to harass and intimidate and well, the benefit to the HOA is large. The benefit to the homeowners is not. That's the issue. The HOA wants power, period. They want to be able to use their power in every way they want to. They have, again, if used purely for the benefit of everybody, everything is fine. But when they have that power they don't like you, so they're going to fine you for wherever you park your car. But George and Bill, who they happen to like, they let them park their car anywhere they want to. That's the reality that happens in these communities. That selective enforcement ability on their power, don't give it to them if they're not entitled to it. This is an opportunity for every homeowner to decide your own fate on that issue. They may be nice now, but in every association, you're one board member away from a total different environment, and in many cases, a nightmare. So be careful. When you make this vote, they will give you a lot of arguments why you should be scared about giving this to the city. But the reality is, there is no difference. The city is actually better equipped to enforce regulations, and it doesn't go away. If you feel that something is wrong in your streets, a call to the city code enforcement will get it fixed. They will, in fact, enforce their laws on your streets, because they're their streets and they're liable. So whether you call the board or you call the city, it's really no difference to you. And you will get better results, more consistent results. There's no political involvement. They don't know George from Bill or Mary or Betty. All they know is somebody's parking where they shouldn't be parking, and they will enforce that parking violation. If they don't hold the vote at all, then under law, the city is not responsible to regulate, and the association loses any authority to regulate the streets, whether it's speed or parking or whatever. But if they fail the vote, then the city takes control, and the association is responsible to notify the city that they are now required to regulate the streets They will send the fire department out or the police department out to look at and survey your streets and determine what their city code requires for those particular seats. They may paint curbs, no parking on this side, they put signs up, whatever. And those are the ways that they would deal with it. And while I'm not looking to overly burden police departments, it's not unusual to simply ask a drive-through to look at streets. It's also important to understand that cities, if there's a speed limit on a street, the city is able to enforce that speed limit with radar. It's not like they have to make new signs, they have them everywhere. And they have municipal workers that will go out and either paint one side of the sidewalk red or yellow or whatever their particular city codes are. I've actually read through a couple of municipalities' codes for parking and speed, and they're much more detailed than what I see in most rules and regulations for associations. So from my perspective, what we tried to do in that legislation is allow people the opportunity to decide. But from my perspective, you are far better off with the city or municipality or county, because there are some communities that have no formal city but are under county control, that they would enforce their own regulations. Primary cause of dysfunction is the lack of transparency, by far. When a board acts or attempts to act in secret, and the people get a feeling that that's happening, then you start developing a lack of trust. And that lack of trust breeds angst and turmoil. So the best thing, our open meeting laws are there for a reason. They're there for that transparency aspect. The open meeting law, from my perspective and my experience, is probably the most violated law in all statutes. Mostly driven by lawyers telling boards that you can do that and you can do that, or you can get away with that, because for the most part they can. Some of the things that I focus on is they provided clarity in the open meeting laws. Yeah. What you can do in executive session right now is only 5 things. And the public policy statement at the end of the open meeting law is very significant. It only exists 5 places in all of statutes. A public policy statement that says how you interpret this statute has to be this way. And the open meeting law says any interpretation of the provisions of this chapter have to be in favor of open meetings. So you can't look at some language and say, oh, well, I can do it this way if you're interpreting the language of the law, it has to be in favor of open meetings. That statement is very, very powerful. It only exists 5 places in the entire statute. And 2 of them are, one for condominiums and one for planned communities. So 2 out of those 5 places are for common interest communities. What can be held in executive session is only the discussion of those 5 issues. You cannot actually act in open session, in closed session, on anything discussed in closed session. You cannot act. That every action of the board has to be in open session where members of the community are allowed to discuss it. That's the transparency aspect. If you're taking action or making decisions in executive session, you're violating the law. That breeds distrust, that breeds angst, that breeds litigation, and disharmony. No, they can discuss it.
Right.
They can deal with all the discussion. They go into open session, they vote to engage in litigation. And they don't have to go into any details. So what you have is the advice of the attorney, the privileged discussions happen in closed session. But the vote has to be. Because guess what? When a board votes to go into litigation, who's going to pay for that? The homeowners. Do they have a right to know that your community is going to start incurring legal expenses for something. That decision, and all that needs to be done is a vote on the decision. Now, homeowners have to have an opportunity to speak before the board votes and to ask questions. Now, they don't have to, the board doesn't have to give them any of the confidential information, but they can respond to issues and get some advice from the homeowners as to whether or not they believe that action is something that is in the best interest of the community. But your board's decision in your litigation case should have been brought up. It shouldn't have been a surprise. Manager, whether it's you're a small community, a large community, you have a volunteer board. The community manager is there to help the board do their job. The community manager works for the board. The company that the community manager works for contracts with the board. The board never gives up their duty to their community. They have specific duties to the community and to the homeowners. Any contract they take with a community manager, they have the responsibility of complying with their duties. The community manager has no accountability to the homeowners. They don't work for the homeowners, they work for the board and the corporation. The same with the lawyer. The lawyer doesn't work for the community, even though community is paying his bills. The lawyer works for the corporation that the board represents. The lawyer doesn't even represent the board. It represents the corporation that the board is part of. So whenever the board is taking advice from a community manager or an attorney, they have to understand that advice has to be taken with a grain of salt, because the board's duty is to the people. Neither of the two other advisors have a duty to the people at all. They will advise them based on their contracts or who's their client. So when you're looking for a community manager, you want skill sets, okay? You want ability to maintain records. You want ability to maintain good financial accounts, to be able to pay bills on time, to responsibly do those jobs, and to interact with the community. Those interaction skills are something that the board should be overseeing and controlling. When there are certain community management companies, one of which is the one that's currently in your community, that believe that the board works for them. That's absolutely false, okay? They like to promote that concept, and they're particular, and they're notorious for it. They do it everywhere they work. They're driving the fact that you do it my way or no way. And my response with that would be, see you later. Community managers are a dime a dozen. You can get 20 more to replace that one who understands their role. Community managers, I deal with just about every firm across this state. They're all the same. The ones that are different are the ones where the board takes charge, oversees the work, and actually drives the community management to do what they want for their community. That's where the community manager acts in the role it's supposed to, the board acts in the role it's supposed to, and the community works better. So, but if the board abdicates everything to the community manager, chaos ensues. Obviously experience, but there's an aspect, and I think the majority, there are very few attorney law firms that I recommend to communities. In fact, there's only one. And the reason for that is not that the attorneys in one law firm are better than others. In these communities, there's fundamental common law that establishes the basis of why these communities can even exist. Why some association could dictate what you do in your private home. That's called property servitude law. That's the basis of law that allows the covenant to be recorded and created, that creates the CC&Rs. If you're looking for a law firm to represent the association, you have to look for one that understands the restatement of law for property servitudes, third, that was issued by the American Law Institute in 2000. If they don't understand and give you advice based on the full common law and case law, and simply look at what you can get away with statutory law, then you will be given a disservice from that law firm. The only law firm I recommend is, from my experience with them, and they're actually going to their training sessions and speaking to attorneys from that firm, is because they get it. They understand that common law dictates even beyond what statutory law will say, and that their obligation to the board is to the full breadth of the law, not what you can fight in litigation. So if you're getting advice based on the ability of the lawyer to make more money in litigation, then you're being disserved by that contract. You cannot have conflicting clients in an attorney. Okay, so an attorney can't work for two clients at the same time. They can only represent one client. So if their client is the association, and the association also has an insurance company, it's through that indirect. They do not, the same lawyer cannot represent both the insurance company and the association, especially if there's different interests associated with that. Now, it doesn't say that an attorney from a law firm can't be on both sides of the issue. So if an individual attorney represents the association and another attorney from the law firm represents the insurance company, that would be okay, but not the same attorney representing both interests. Nothing other than simple jurisprudence and their code of conduct. And I'm not an attorney, so I can't speak as an attorney, and I have no right. But from my experience, there's very little ethics in HOA law firms. That's allowed to continue. It's a disservice to the whole law profession, a legal profession, and it's what the Arizona bar job is to do. But I personally have sent in specific requests to the bar to discipline attorneys, and it was essentially dismissed. The Supreme Court is the organization that defines everything in the judicial branch of the government. Right. So the lawyers work in the judicial branch. The legislation can't even control the lawyers because they're in a whole different branch of government. So when I work to statutes, I can't regulate attorneys in state statute. Only the Supreme Court can dictate the rules of attorneys. Ultimately, the bar and the Supreme Court are the judge of the performance of the attorneys within their jurisdiction. First thing is to join my website, okay? Become a member of the coalition. There's no cost. It's totally free. All I ask is then when I'm looking at legislation, I will write to everybody that's a member of the coalition and ask for some support, either a specific letter or a note or a phone call. And those go a long way. The more that legislators hear the voice of their community, the better, the more likely that we're going to get reform. Like I said, I don't believe in big government. I don't want to create another bureaucratic organization looking to regulate these communities, because in the 11 states that do it, there's no real difference, because the industry populates that regulation bureaucracy, and it's the wolf guarding the hen. So simply join my website, become a member of the coalition, spread the word. The more people know that there is somebody there who is willing to help you and deal with the problems. I travel across this state to speak to communities. I will speak to any community that asks, whether it's the board or the members themselves, to help them understand what the law is and what recourse they have and what it should be. My goal, while I don't necessarily like the concept of HOAs, I think there's a place, and they're not going to go away.
Yeah.
3.5 million people live in this state in either a condominium or an HOA. So half the population of the state lives in one of these communities. They can't all be wrong. That I put into law in 2022, okay? So it's what's called the informal meeting of the members. So what we did in that statute is said that the community cannot stop the members from gathering. It's essentially the freedom of speech and the freedom to assemble peacefully, to discuss community issues. So if you want to create an informal meeting of members, you can make the reservation for the meeting space, and then you can post on every bulletin board in the community a notice of that meeting, asking anybody to attend. Any homeowner is welcome to attend that meeting. You can also invite an outside guest to speak at that meeting, including a political candidate. If, again, we just went through elections, I really encourage people and the members to invite political candidates using that statute to informal meetings of the members and to have an opportunity to interact with your political candidate, but also to inform that political candidate of the issues that you face as a community. It's a very powerful tool, and we codified that into law in 2022. That is, if you are going to do an action or to deal with a petition, these informal meetings of the members have to be allowed by the association. They cannot restrict you from using common property or even your own private property to have these meetings. One aspect that's important on that is the guest. The way the statute was written is that any homeowner can invite one guest. But if you get 10 homeowners, you can invite each individually one guest for 10 guests to come to that meeting. So if you had a speaker and you had 3 speakers that you wanted to come, it just needs to be invited by 3 individual homeowners to comply with the law. And the association can't stop you from doing that. One thing that every community can really help me with is contact your legislature. Tell them that you want to have something to help homeowners protect their rights in these communities. Make it important to them. Write a letter, call their office, have them note. The more legislators hear from their constituents, the more likely I'm going to be very well received when I go to help them write any statutes. So while I have my own legislators from my district, but I'll work with any legislator on any side of the political spectrum, because HOA issues or condominium issues are not partisan. I've worked very hard to keep it out of the partisan. God knows how many issues are partisan within that we face, but HOA issues are not. We can get legislation sponsored from a Democrat as well as from a Republican to help homeowners in their district. And but they need to hear from you. If you can, the more homeowners write to them, the more likely that they will contact me to help them with something I either already drafted or something that they want to focus for their particular constituents.